All right. All right, crazy kids. Hello, Sam. Hello, Lily. Fifth and Sixth Amendments. This is a pretty short lesson. What you really need to know is you got to know Gideon. We spent a lot of time on Gideon. We briefed it, watched a movie on it. I'm not going to spend a lot of time on that. And you have to know Miranda. Remember, all of these rights in the Fifth and Sixth Amendment that I'm going to go over have been incorporated, which means they're enforceable against who? Starting with an S. Through the 14th Amendment. What clause? By the process of, and you should all know those by heart, all right? Okay, Fifth Amendment. This is one of the few rights in the Bill of Rights that has not been incorporated. You won't see it on the test, except maybe a reference to it not being incorporated. I doubt it. This is just for your more education. What is an indictment? For federal crimes, a prosecutor has to go to a grand jury. A grand jury is 23 citizens that sit and listen to a one-sided presentation by the prosecutor to try and convince the grand jury that there is probable cause, a very low standard. If a majority of the grand jury believes that there is probable cause, remember the defendant can't be there to present the defendant's side, then the grand jury will issue what's called an indictment, which is the formal charging document that charges somebody with a crime. In state court, they don't have to do that. They can file a complaint. The prosecutor can, straight with the court. But if the state goes that route, they have to, in Arizona, within 10 days, hold what's called a preliminary hearing, where the prosecutor gets up in front of a judge and convinces a judge that there is probable cause for the charge to go forward to trial. Double jeopardy. You guys all remember that? Double jeopardy. You can't be charged twice for the same offense, which means once you've been found innocent by a jury, they can't re-prosecute you. If you were found guilty the first time, they would never re-prosecute you because they've already convicted you. Okay, there is a due process clause in the Fifth Amendment. Interestingly, it is the exact same language as the 14th Amendment. No person can be deprived of life, liberty, or property without due process of law. I am a state employee. The state government can't fire me without giving me due process. If I was a federal civil service employee, I could not be fired without giving me due process, which at a minimum would mean I would have notice that I was being fired and an opportunity to go in front of some sort of hearing, maybe just with my boss, whatever, and present my defense. So even the federal government can't interfere with fundamental rights. Now, this is usually easy because our fundamental rights are listed in the Bill of Rights, and the Bill of Rights is enforceable against the federal government. But the right of privacy is also enforceable against the federal government in those areas like Washington, D.C. or Puerto Rico, which are ultimately have their sovereignty from the federal government. The federal government, for example, could not violate Roe versus Wade because that is a fundamental right. I get it. The Supreme Court has said that this fundamental right arises out of Douglas's penumbras in Griswold and are therefore connected to the Bill of Rights, but whatever. Fifth Amendment has the takings clause, the right of eminent domain. Eminent domain says the government cannot take your property for public use without just compensation. This has been incorporated. It applies to both federal and state governments, although every state constitution also has a takings clause. All right, this is the most important part of the Fifth Amendment. The right against self-incrimination. This is a constitutional privilege against self-incrimination. It says no person shall be compelled to be, excuse me, a witness against himself. Now here's the weird thing. Read that language. No person shall be compelled to be a witness against himself. That sounds an awful lot like trial, doesn't it? That sounds like you can't be brought into trial and be forced to answer questions. As a practical matter, this means at trial, the government cannot call you, the defendant, as a witness in their case when they are prosecuting your case. When you decide to do your defense, you can decide whether or not you want to testify. But if you don't want to testify, the jury is told that they can't hold that against you. But here's what happened. The Supreme Court kept getting case after case, where people said this right of self-incrimination at trial is meaningless because I was interrogated by the police and they coerced me into falsely confessing. They coerced me into falsely confessing when I was interrogated by the police. What is coercion? Coercion is the police using force or threats. Has anybody heard the term third degree? Give somebody the third degree? It comes from a famous detective manual in the early 1900s, where the first degree was talking nice, the second degree was like really getting in somebody's face, and the third degree was beating the tar out of the guy. So here was the problem. Defendants would go into court, they would exercise their right to remain silent, or they would get up and testify and say, I didn't do it, and then the police would present evidence of the confession. And the simple fact is, when a jury hears a confession, that's pretty much, the case is over. You are in deep trouble and you will probably get convicted. So, to address this problem, the Supreme Court resolved the case of Miranda. All right, so to help prevent so many coerced false confessions through coercion cases, the Warren Court decided on Miranda warnings, decided on to require the police read a warning to any defendant in custody that is being questioned. So the problem was coerced confessions. The remedy, the Supreme Court said in Miranda versus Arizona, is you police officers have to read Miranda rights to somebody, and if you don't read them Miranda rights when you question them, then any confession you get is excluded from evidence. All right, Miranda. Miranda said, before questioning, if the confession is going to be used in evidence, evidence in favor of the government, before questioning, the police must inform the suspect in custody of his right to, and you guys all know these from TV by heart, right to remain silent, anything you can say can be used against you, you have a right to speak to a lawyer, and have one present during questioning, and if you can't afford a lawyer, one will be appointed at government expense. You guys all know those by heart. Okay, here's the interesting thing. Miranda only applies when, number one, you are in custody. So, assume a police officer walks up, there's a dead man laying there and a crowd around the dead man, and the police officer said, hey, who killed this guy? And somebody said, I did. You know what? That person wasn't in custody. Miranda does not imply. Person also must be interrogated. Let's say you're in the back seat of a police car and the cop is driving along and he's not asking you any questions, and you say, oh, by the way, I killed that guy. There's no Miranda issue because you were not being interrogated. You were not being questioned. So if you are in custody and being questioned by the police, you have to be given your Miranda warnings, or your confession cannot be used by the government. Okay. This is a connection to Mapp versus Ohio, the exclusionary rule. If you don't remember that, go back to your Fourth Amendment notes and look at that. You must know the exclusionary rule. The exclusionary rule says evidence taken in violation of the Fourth Amendment, or now somebody's Miranda rights cannot be used in trial. Cannot be used in trial by the government. Just so you know, won't be relevant to AP, but subsequent to Miranda, in a case called Doyle, the Supreme Court said, okay, statements taken in violation of Miranda, the government can't use in its case, but if the defendant gets up in the defense case and says something different than his confession, then the government, in their rebuttal case, follow me, can call the police officer and tell the jury about the confession. This totally guts Miranda. So here's what a cop does. A cop says, in an interrogation, he'll say, "Did you kill the guy?" "Yes, I did." "Okay, now I'm going to read you your Miranda rights." "Did you kill the guy?" "I don't want to talk. I want to assert my right to remain silent." So a cop has a statement, a confession taken in violation of Miranda, and no confession taken in compliance with Miranda. Now we go to trial. During the government's case, they cannot use the confession, but if the defendant in his case gets on the witness stand and says, "I did not kill the guy," now the government can call the police officer in their rebuttal case and say, "Oh, he told me he killed the guy." You follow me? So it blew a huge hole in Miranda. By the way, I've been watching a lot of Netflix and these British cop flicks, and it's interesting. Here's what the British say to people that are being arrested. "I'm arresting you for whatever, whatever. You do not have to say anything, but it may harm your defense if you do not mention, when questioned, something you later rely on in court." Interesting. Anything you may say may be given as evidence. How is this different than America? In America, we have a right against self-incrimination. In England, apparently, from this language, and at trial, the prosecutor could say, "Hey, we asked him what happened, and he refused to talk to us. And now he's come up with this big story as a defense." In other words, a prosecutor in England apparently could make a comment to the jury to hold a defendant's silence in a police interrogation against him. That cannot happen in American courts because we have the right to remain silent, and that cannot be held against you. Okay, Sixth Amendment, right to counsel, Gideon versus Wainwright. By the way, this is not a typo. That's the way they spelled defense in the Constitution. "In all prosecutions, the accused shall have the assistance of counsel for his defense." The big issue on this is what happens if you are too poor to afford a lawyer. What happens then? You don't have to remember all this, but there was a progression. You know, this is kind of relevant talking about Gideon versus Wainwright, because one of the arguments that would be made in Gideon versus Wainwright more forcefully, if it was argued today, is the original intent of the framers did not mean giving somebody a lawyer if they were too poor to represent them. So we shouldn't interpret the Constitution that way today. For federal crimes, Congress passed a law that said you get a lawyer if you are going to be executed by the federal government. Powell versus Alabama, that was the Scottsboro boy case, those black boys that were accused of raping girls on the train. Supreme Court said, this is incorporation, right? Incorporation of right to counsel for poor people in capital cases. Capital cases means somebody can be put to death as punishment. Back to federal, not incorporation, just the 6th Amendment, not the 14th and 6th Amendment. The Supreme Court expanded right to counsel for poor people for all felony cases in federal court, federal laws. Betts versus Brady, remember the movie. This was the case overturned by Gideon versus Wainwright that said in state courts you get a lawyer if you can show special circumstances. Sam, why are you growling at the globe? All right, crazy boy. Yes, I love you too. Then Gideon versus Wainwright, all felony defendants. Remember the oral argument in front of the Supreme Court where Abe Fortas, Gideon's lawyer, was arguing that we should update the Constitution to be civilized. The current rule is the right to counsel includes misdemeanors now if there is a substantial risk of jail time. Sorry, you guys getting criminal traffic tickets. There is no risk of jail time on those. You do not get a lawyer. Sam! Quit growling at the globe. Okay, there are other 6th Amendment protections that help you mount a defense. All of these have been incorporated. You should just briefly know they exist. You have the right to be informed of the nature and cause of the accusation. In other words, you have the constitutional right to be charged with a crime. In Arizona, you have to be charged with a crime within 48 hours under Arizona law, which complies with the Constitution and with Sam's sense of justice. You have the right to confront witnesses. In other words, you have the right to cross-examine witnesses at trial. And you have the right to subpoena witnesses that are going to testify favorably for you. And that's a compulsory process. That's called a subpoena. A subpoena is an order by a judge to a person that they have to come and testify. You have the right, don't worry about that, we're not going to talk about that. You have the right to a speedy and public trial by an impartial jury. All of these have been incorporated. They were all incorporated by the Warren Court. That is it. You must know by heart Miranda. You must know by heart Gideon versus Wainwright. And you must say hello to Sam and Lily. All right, guys. Signing off.